Mr. Mayor, we're live.
Thank you very much, Madam Clerk. I'd like to welcome everybody to the council meeting of Wednesday, January 22nd. I'd like to call this meeting to order, but before the land acknowledgement, I'd like to address some housekeeping items. Please silence your cell phones while in chambers, and members of the public speaking at the podium and council members before addressing council, please take time to adjust your microphones so that you are speaking clearly and directly into the microphone. The Township of Oro-Medonte acknowledges that we are situated on the traditional land of the Anishinaabe people and ancestral territory of the Huron-Wendat. The Anishinaabe include the Odawa, the Ojibwe, and the Potawatomi nations, collectively known as the Three Fires Confederacy. It continues today as the home for diverse Indigenous peoples, including the historic Métis community in Penetanguishene. The Anishinaabe people continue to have an enduring relationship with this land, specifically the Chippewas of Brahma First Nation, the Chippewa Tri-Council, and the Williams Treaty First Nations. The Huron-Wendat Nation also continues to pay respect and protect their ancestors and heritage on this land. We honor the Indigenous history and culture that has thrived for millennia in this territory and the treaties that bind us together as partners in the spirit of shared, sustainable, and prosperous future. We are all treaty people. Our commitment begins with acknowledging the truth so that we can move forward together towards reconciliation. Miigwech. May we have a draft motion to adopt the agenda, Madam Clerk?
Moved by Shell, seconded by Young. Be it resolved that the agenda for the council meeting of Wednesday, January 22nd, 2025 be received and adopted as amended to amend item 11A, DS 2025-004 report as revised, and to add as item 13B, Deputy Mayor Lavoie request to amalgamate the Lake Simcoe Regional Conservation Authority, LSRCA, and the Nottawasaga Valley Conservation Authority, NVCA, into one authority.
Thank you very much. I'll call the vote. All in favor? Opposed? I see none. That is passed. May we have a motion to go past 4 hours if necessary, Madam Clerk?
Moved by Hutchison, seconded by Lavoie. Be it resolved that Rule 14.20A, as per the procedural bylaw number 2023-043, be suspended in order to allow the meeting to proceed past the 4-hour adjournment requirement if necessary.
All in favor? That is carried. And does anyone have any pecuniary interest to disclose at this time? Councillor Schell.
Yes, item 11A, your short-term rental document. I own and operate a legal short-term rental, so I won't be stepping aside for this.
Okay, thank you. Any other pecuniary interests? If you do find you're in a situation later in the meeting, just let us know at that time. And may we have a motion to go into closed session, Madam Clerk?
Moved by Lavoie, seconded by Bard. Be it resolved that we do now go into closed session at 3:04 p.m. to discuss position plan procedure criteria or instruction to be applied to any negotiations related to the municipality, intermunicipal relationships, and provincial facilitator. Education or training of members in accordance with Section 239 3.1 of the Municipal Act 2001 as amended, Finance Department.
Thank you. Call the vote. All in favor? That is carried. So we'll see everyone closed, and I expect we should be back and open by 4 o'clock. Okay? Thank you.
Mr. Mayor, we're live.
Thank you very much, Madam Clerk. Welcome everyone back. Could we have a motion to rise out of close, Madam Clerk?
Moved by Clark, seconded by Young. Be it resolved that we do now rise at 4:26 p.m., at which time we shall report on the closed session items 4C and D.
Okay. We'll call the vote. All in favor? That is carried. And may we have a motion, may I have the motion for 4C, please?
Moved by Young, seconded by Lavoie. Be it resolved that staff participate in discussions with the Office of the Provincial Land Development Facilitator on the proposed Stage 3 work plan proposed by Hampson Consulting.
Any questions? Seeing none, all in favor? That is carried. And we have a motion for 4D, please.
Moved by Hutchison, seconded by Shell. Be it resolved that confidential report FI 2025-016, Sean Binns, CAO, Shannon Johnson, Director of Finance, Chief Financial Officer, re-education or training of members in accordance with Section 239.3.1 of the Municipal Act 2001 as amended, Finance Department, be received.
Call the vote. All in favor? Opposed? There are none. That carries. May we have a draft motion for the draft minutes, Madam Clerk?
Moved by Bard, seconded by Hutchison. Be it resolved that the draft minutes of the council meeting held on Wednesday, December the 11th, 2024, be received and adopted as printed and circulated.
All in favor? That is carried. Item 6, recognition of achievements and introductions. We have none. There are no public meetings and there are no deputations or presentations on tonight's agenda. Is there a member of the public present that request an agenda item be moved forward, as they won't be staying for the duration of the meeting? Seeing none. Open forum. Madam Clerk, have we received any registration from the public to provide verbal comments on agenda items tonight?
Yes, Mr. Mayor, we have Jane Voorhees on item 11B.
Okay, thank you. Ms. Voorhees, if you want to come, adjust the mic. Just state your name and proceed when you're ready, please.
Hello, everyone. Hopefully everyone had a good Christmas. I know you've been super busy since you got back. So I'm speaking to, is it 11B? Is that the number? Yeah. Please correct me if I'm wrong, but it's my understanding that following the submission of the Hampson Stage 2 report in early December to the Provincial Land Facilitator, all municipalities involved agreed to provide recommendations on whether to proceed to Stage 3 by mid-January. So as a result, I understand that we're here today to review a staff report by Mr. Van de Boncoeur and Mr. Binns, which provides recommendations to council on that matter. So given the significance of the decision to move to Stage 3, I find it's both unfortunate and a bit concerning that this report, the Hampson report, after taking months and months to be prepared, and that it was, in my opinion, a couple of months late and overdue, was released to all the municipalities in December, in the Christmas time, in the winter holiday break, with a decision to be made in approximately 1 month. So my question really is, why the rush? I have concerns about that and the timing of that. That being said, I want to acknowledge and appreciate the hard work and the excellent analysis by Mr. Van de Boncoeur and Mr. Binns in their staff report. I want to say I fully support this report's call for clarification on specific data as outlined in option 3 of your report. However, I am firmly opposed to proceeding in any form of stage 3 at this time, and I'll explain why. Municipalities, including ours, have invested a lot of money. I think our township has 10 to 20,000, you'd have to correct me on the exact number for that, of council and staff resources into the stage 2 land need assessment. As the staff report highlights, there remain many unresolved questions about growth scenarios, unrealistic intensification targets by Barrie, and land definitions that must be addressed. To be very clear, stage 2, in my opinion, is incomplete. We need more clarification on the data. Any decision to advance to stage 3, in my opinion, would be premature and could commit our township and its residents to a process that may be difficult to justify and to defend later. It is critical, in my opinion, that all municipalities involved reach a consensus on the factual baseline land needs data presented in stage 2 report, rather than relying on assumptions and opinions. For example, the City of Barrie reviewed the stage 2 report and estimated a need for 4,000 acres of additional land, citing its experience with Innisfil annexation and concluding that 40% of the annexed lands are typically undevelopable. However, the Hempson report study itself states that Barrie has sufficient employment lands to meet its needs and requires additional land only in the range of 654 to 1557 acres in Springwater and Oro-Medonte for residential and community use purposes. In fact, the County of Simcoe, represented by Warden Basil Clark, expressed disappointment with Barrie's last-minute request for land, which contradicts prior findings and bypasses collaboration with partners and expert evaluations. He also highlighted past issues with Innisfil land being allocated without due process and stressed the need for balanced growth. Proceeding to stage 3 without an agreement understanding of the land needs from stage 2, in my opinion, would be a significant oversight and could result in unnecessary costs, potentially amounting to thousands and thousands of dollars. To make informed and responsible decisions, all municipalities, the City of Barrie, the County of Simcoe, Springwater, and Oro-Medonte must be aligned on the baseline data from the Hempson report. And at this time, that alignment has not been achieved. I believe that Oro-Medonte's interests and need for clarification on stage 2 can be confidently and effectively represented by our mayor, deputy mayor, and CAO to the provincial facilitator, Mr. Schelling, prior to any agreement to move forward to stage 3. This process should not be rushed. The proposed boundary adjustment is a pivotal issue for our community, with far-reaching implications for our rural lifestyle and our culture. To safeguard our future, we must prioritize accuracy, baseline data, and collaboration as we navigate forward. Thank you.
Thank you very much, Ms. Voorhees. And I know this isn't a question and answer period, but I'm sure a lot of the matters you bring forward will be addressed after open forum in Mr. Van Vancour's report. And he will be able to speak to some of those things, hopefully. Okay?
Yes, thank you very much. Thank you for listening.
Madam Clerk, is there anyone else registered to speak?
No, Mr. Mayor.
No.
There may be somebody in the gallery.
Okay, so at this point, if anyone else would like to speak to any items on the agenda, if they would like to come forward to the microphone and just state their name, and don't all jump up at once, though. No? Okay. Well, if there's no one else, then that'll bring a conclusion to the open forum. And we'll move on to item 11A, reports of municipal officers. Mr. Van McCourt, would you like to provide the summary comments to 11A? Oh, sorry, just give me one minute. Sorry, thank you, Councillor Schell. Mr. Van Boncourt, whenever you're ready, please proceed.
Thank you, Worship, members of council. It's my pleasure to present the highlights of an options report to address illegal short-term rental accommodations in Oro-Medonte. This report follows a series of reports that were brought forward to council over the fall. And I just want to make it clear before I get into the body of the report that the recommendation pertaining to licensing only pertains to legal short-term rental accommodations. And in Oro-Medonte, short-term rental accommodations are only permitted in two zones, the Village 1 zone and the Residential 2 exception zone. Those are the only two areas where legal short-term rentals are permitted. Everywhere else in the municipality, short-term rental accommodations are excluded. And for the purposes of this discussion, I'm going to exclude bed and breakfasts, although bed and breakfasts are a form of short-term rental accommodations. My comments pertain to what's traditionally been referred to as short-term rental accommodations. So the recommendation pertaining to licensing only pertains to those short-term rental accommodations that are legal. That means that they meet the zoning bylaw. That is fundamental to any kind of licensing regime. You need to meet the municipal requirement. In this particular case, the zoning provision is mandatory. So with that clarification, Your Worship, I'll just jump into my report. And over the last several months, we've talked to council about different enforcement tools that council may wish to use with respect to enforcing illegal short-term rentals. One of the tools was a zoning bylaw, and we heard a little bit about the opportunities and constraints in terms of using the zoning bylaw. And I just talked about the zoning bylaw only permits short-term rentals in two specific zones. Every other zone, they're not permitted. And as the little map in the report indicates, we have, as of October, there's approximately 294 unique rental units, units being offered for rent that are short-term rentals. And I found out today from Granicus that there are 166 listings in the two zoned areas. So we have 394, we have 166 in those two zoned areas. So there's 200 potentially that are operating illegally in the municipality. So from the municipality's perspective, in the past it has tried to use the zoning bylaw as a mechanism to enforce illegal STRs. There are limitations with respect to using the zoning bylaw. The largest limitation is the evidentiary requirement to prove without a doubt that a short-term rental is taking place. So that's the main limitation of the zoning bylaw. Another enforcement tool that the municipality could use is Section 440 of the Municipal Act. And Section 440 of the Municipal Act is a powerful tool that the municipality can request the Superior Court for an order to restrain an activity from taking place. And the municipality needs to bring a material forward to the court. It needs to have evidence, affidavits from witnesses, and the property or the owner of the property that under a Section 440 application would be given the opportunity to refute the information provided by the municipality. But it is a court action, and it's very powerful. If the municipality is successful, an issue or an injunction is issued by the court saying that that use cannot occur on that particular property. It is a legal process, and it does have costs associated with it. Legal costs that can vary between $10,000 and $30,000 per application. The next tool is municipal licensing. And as I indicated, Your Worship, members of council, municipal licensing is only applicable where legal short-term rental accommodations occur. But the way the bylaw is structured is that you put in a number of prohibitions with respect to advertising short-term rentals that are not licensed. So there's a prohibition. If you're not licensed, you cannot advertise. If you're not licensed, you cannot rent. So there's a number of specific provisions in the licensing bylaw. So what happens is that if illegal short-term rental is identified, and it's typically identified by an advertisement, by the provisions in the licensing bylaw, they're guilty of an offense. And if they've rented, they're guilty of another offense. And if they don't take their advertising down, they're guilty of another offense. So these penalties can add up, and they can be quite significant, and I'll get to that in a few minutes. There's a number of provisions that are general provisions that are included in licensing bylaw, and I've outlined a few of them. And one of the points that was made was referenced to me, and I appreciate Your Worship, members of council. I received 8 emails from residents who shared their concerns with respect to the report. A lengthy detailed letter from a residents group expressing their concerns, and I appreciate all those comments that came in. But one of the comments, and it wasn't specifically covered in my report, but it's particularly, it is in licensing bylaws that I've reviewed that impact rural municipalities, is that part of the approval process for a legal short-term rental accommodation is that there needs to be verification that the septic system can support the uses on the property. And that wasn't specifically referenced in my report, but I want Your Worship and members of council to understand, and the public to understand, that that would be part of the review process to ensure that the septic system is satisfactory, that, you know, for whatever purpose is being proposed. Part of the review was to look at a number of municipalities. In the report, it's referred to as a benchmarking exercise, and in the report, I've outlined a number of the municipalities in terms of what they've done with respect to licensing, and provide a brief explanation. I've given some links to websites that, through those municipalities, they've got lots of information with respect to the regulation of short-term rentals in their communities. A number of them have the municipal address of the legal short-term rental, the contact information listed on their website, so if there's a concern that the person can contact them directly. Quite a lot of information, but most of the municipalities that I benchmarked, and this is consistent across the province, and I didn't cover all municipalities, most of them do have, or they've chosen to try to regulate, and they have a licensing bylaw. Councillor Hutchinson reached out to me and asked me about the town of Blue Mountains and the township of Tiny, and I thought about including them, and they're unique situations. They both have licensing bylaws in place. I'll start with the town of Blue Mountains in the sense that the town of Blue Mountains has had a licensing bylaw for a number of years. And they've had some struggles. They've recently amended their licensing bylaw. And my understanding is that things are in a better place than they were. But back when they introduced short-term rental accommodation, they went through a whole process. And then at the end, and it's not clear to me how this happened, but they allowed approximately 50 existing short-term rental operators that weren't zoned to continue to operate. And that caused a lot of problems in the sense that a number of those in that approximate 50 were the worst offenders on of their licensing bylaw. They had some issues with respect to enforcement and whatnot, but as I said, since I understand recently that things have improved. So that's the town of Blue Mountains. With respect to the Township of Tiny, recently implemented a licensing bylaw regime. A part of one of their features, similar to some of the other communities that were benchmarked, is they put a cap on the number of short-term rental accommodations permitted in their municipality. And in Tiny Township's case, they put a cap of 300 short-term rental accommodations for that municipality in a calendar year. And at the time, they had identified through the similar process, they had more than 457 short-term rental accommodations. So there was a group in the township that challenged the municipality in terms of placing a cap in its licensing bylaw with respect to limiting the number of licenses. So that challenge went to court, and the basis of the challenge was that licensing is just dealing with the use and making sure that it meets all the requirements. It's not intended to prohibit the use. And by putting a cap of 300, you were prohibiting the use. And I'm paraphrasing because I'm just going on information provided to me. So those were the two that I did not include, but they were kind of outliers in the sense that they had special circumstances. One of the things that a lot of municipalities have implemented, and it seems to have gained momentum, and I was really pleased to see that the Township of Oro-Medonte has done this, is it's implemented an administrative penalty system. And council just adopted a bylaw in December, an AMPS bylaw, after consideration in the fall of a number of reports. And this administrative penalty system applies penalties outside the court system. So where somebody has violated a bylaw, then they are issued a notice that they are required to make a payment to the municipality of whatever that violation amount is. And they have the right to appeal. And there's typically an appeal officer. They listen to the appeal, but if the decision is to uphold the penalty, then that penalty is levied and the individual has to pay it. And one of the nice things about the administrative monetary penalty system is that under the Municipal Act, that the penalties, if they're not paid, they get transferred on to the taxes of the property owner. So it's not like somebody can ignore the penalty. And a number of AMPS bylaws, especially the ones that I've done the research dealing with short-term rental accommodations, a single advertisement of a short-term rental accommodation that's not licensed, it's $1,500. That's for one advertisement. So you could conceivably average day 1, day 2, day 3. You know, there's no maximum. If you had a rental of there was a rental of an illegal short-term rental, and verification, that's another penalty, and that can be stacked. You can stack these these AMPS penalties. So the municipality has the AMPS program now in place. So when looking at the options for council to consider, we looked at using the zoning bylaw, using section 440, using the licensing bylaw, or using a combination of a licensing bylaw and section 440. And the recommendation is that council proceed with a licensing bylaw, as well as proceed with enforcement under section 440. One of the things I learned through this process is that section 440 charges or orders are typically sought where there is a significant issue to be addressed, like there's a public safety matter, or it's a significant nuisance or something. It's not something that's just done, but it is a tool, and it has been suggested to me that it could be quite an effective deterrent. And I don't disagree, Your Worship, members of council. I think it could be, but I think it has to be done selectively and considering the cost involved. In conjunction with the recommendation, having the right data, having the information is critical. And that's where part of the report is recommending that the municipality engage third-party assistance. Granicus, which is a company that's used by a number of municipalities, as you saw through the benchmarking. They have 3 modules that are particular interest, and those seem to be the common ones that are used by municipalities. There is the address identification module, and they scan 60 plus sites. There's in fact over 100 sites, but their regular 60, they're always scanning to see what new rental listings are popping up. And as I said to you earlier, if somebody pops up that's an Oro-Medonte and they're not licensed under a licensing bylaw, boom, they'd be subject to a violation. So they provide address information, screenshots of the advertisement, et cetera, et cetera. So that's all given to the municipality, and that would assist us with any section 440 application. Compliance monitoring is another module to ensure that they're meeting all their the zoning and any permit requirements. And they provide a 24/7 hotline, and that members of the public can call this hotline and with a complaint, and they will contact the person responsible for the property or the short-term rental and advise them that they've received a complaint, and staff are notified as well. So again, we've got coverage for those off hours that we tend to get complaints and we have nobody to respond. So, Your Worship, I'm just going to start to wrap up in terms of the report. There is a cost in terms of drafting a new licensing bylaw. From staff's perspective, we want to make sure that the licensing bylaw, if that's the direction that council gives, is drafted with all the current standards, all the current language, and can withstand any tests that may be launched against it. So a proposal in the report is that the township engage an outside resource, Paul Drain Associates, to draft the licensing bylaw. And members of council may recall Mr. Dre was here to present his experience with respect to prosecutions and whatnot. And the second part was with respect to continue to explore the options with respect to using Granicus as a third-party resource for the municipality. Your Worship, as a result of the input received from members of the public with respect to the timeframes outlined in the report, a modified recommendation has been put forward. certainly the timeframes that were in there, and one of the bullet points provided for a public information outreach meeting that would be held to discuss the licensing bylaw. But, excuse me, some members of the public indicated that things seemed to be moving fast and they were having trouble digesting everything, and they asked for more time to properly digest and to have input into this process. So on the screen there is a modified recommendation, and I'll read it out. Paragraphs 1 and 2 are the same as what was in your original staff report. Number 3 is new, that council directs staff to prepare a draft licensing bylaw as recommended in the report. Number 4 is new, that council directs staff to hold a public information consultation session on the draft licensing bylaw, which would include information on how it relates to the licensing of legal STRAs only permitted in 2 zones in the township and bed and breakfast establishments, information on the requirements to obtain a license, steps that the township would take to enforce the licensing bylaw if enacted by council, information on the administrative monetary penalty system and how it would work. Number 5 is the same. And number 6 is that staff report back to council on the comments received at the public information consultation session and recommended next steps. So, Your Worship, that concludes my presentation, and I'd be happy to take any questions that members of council may have.
Thank you very much, Mr. Van der Vancourt. And I think the one comment I want to lead with is the comments that we've received, and we've received a number of comments over the past week regarding this matter, and that's why Mr. Van der Vancourt was very clear to articulate with clarity the process that will take place. You know, there's no use building a solution unless it's a sustainable solution, and the best sustainable solution is with public input and feedback. So the process is, if council gives direction to move as laid out, that there will be public engagement for feedback on the bylaw and how we move forward. And after that's been received, they will go back and further tweak and amend before it comes back to council for consideration. So I think that's very important, and I think it's great that Mr. Van der Vancourt and the planning staff have listened to the comments that have come in and made the proper adjustments to make sure we do this right. So council, I'll now open the floor for any questions or comments at this time. Sorry, Councillor Clark.
Thank you, Mr. Mayor. Through you to Mr. Van der Vancourt. Apologies if I'm still pronouncing your name incorrectly. Just to go back, if you could provide me with some clarity. So you had mentioned that you can obviously stack advertising, I'm going to call it a fine, under a potential bylaw like this. So would that depend on the language? So if they were advertising on VRBO versus Airbnb versus, you know, the other multiple platforms, would it be a fine per instance of advertising on a day, or could it be a per fine per site per day? Because obviously those charges, if they're using multiple platforms, could be quite exuberant.
Thank you, through you, Your Worship. Thank you for the question, Councillor Clark. So yes, some of these advertisements are on multiple platforms, and it would be brought to the municipality's attention that the advertisement appeared on platform XYZ, and depending on how the bylaw is drafted, conceivably that person would be subject to 3 administrative monetary penalties. Could be $50, could be $150 per advertisement, because they were advertising an STR that was not licensed.
Supplemental?
Yes, thank you, Mr. Mayor, and forgive me, but I think it'd be important for the public to know as well, if we're able, if this is something that does come to fruition, what is the legal ramifications if someone were to come to challenge the municipal bylaw, and what court does that occur in? So to clarify, so if we were to go forward with a licensing bylaw and, Mr. Joe Smith, I hope there's no one in the township named Joe Smith, said, I don't like that bylaw, I'd like to challenge that, what court does that go through? How do they challenge, or how would a challenge come through?
And I'm, through you, your worship, to Councillor Clark, I'm not 100% sure how that proceeds, but I'm just going to use the Township of Tiny example that I referred to earlier, where the challenge was made to the Superior Court.
Thank you.
No, and I understand, because where I got the confusion is if it's being implemented as an AMP, like, because we don't have, like, it would be an AMP charge, correct? I don't know the answer either, Mr. Van Vancourt, but so if the charge is through an AMP for illegally advertising, can it be dealt with within the same process?
Thank you. Thank you. If that's what the Councillor Clark's question was getting to. But yeah, I'll answer that one as well. So, so the first step would be, say, for example, we use the example, the person receives a notice that they've been advertising on 3 platforms. They've got administrative monetary penalty of $50 times $350. So their first step is they can attend at the municipal office or through an electronic means and appeal that. And there's an appeal officer, would be Curtis, or somebody that our manager has designated as the appeal officer. That person would deal with that as the initial response. If the person is not satisfied with that, then they can appeal it to an independent adjudicator. And in the AMPS bylaw, there was identification that the municipality would have to appoint somebody to be this independent adjudicator. And that individual would conduct a hearing and listen to the evidence and make a decision. And then that would be it. There's no further appeal to the courts. It's the appeal officer, then there's the hearing officer, and then that's it.
So there is no path, excuse me, for them to take it to a divisional or superior court?
No, there isn't. I thought the councillor's question had to do with the actual licensing bylaw itself, yeah.
Okay.
Yeah, just to add clarity, that was my question, was to the actual licensing bylaw, but I think having clarity for both situations is positive.
Okay. Thank you. Councillor Hutchison? Oh, okay. No. Any other questions or comments at this time? Councillor Bard?
Thank you, Mr. Mayor, through you to Mr. Vadencourt. I might be getting a little ahead of the game a bit, but you were saying like having a limit or a cap is a bit of a problem in this. Would having minimum distances or a maximum distance between the properties be seen similar to that, do you think? Like, I guess I wouldn't like to see 3 or 4 of these properties side by side by side.
Through your worship to through the councillor, so it would be a challenge to address that, in the sense that we're a rural municipality that has some condominium units and whatnot, and the units that are currently legal are in apartment style buildings, so having a separation distance may be difficult. I know that there is one municipality that, when I was looking through the benchmarking, that had put minimum separation distances in their bylaw. I think it was 300 meters that there was a requirement, that but that was in more of a rural area or a shoreline area type thing. And I think that if you had, some municipalities do not have a zoning bylaw that restricts a short-term rental accommodation. So because of that, short-term rentals have been viewed as being a residential use. And so municipalities have tried to limit the impact by putting a separation distance between them so that the impact is lessened on the surrounding neighborhood.
Thank you very much, Mr. Van Boncourt. Look around and all of a sudden there's yellow everywhere. Councillor Hutchison and Deputy Mayor Lavoie.
Thank you. Through you, Mayor Greenlaw, to Councillor Bard. Yes, the majority of the legal STRs are within the Carriage Hills Resort and Carriage Country Club in the Village Commercial Zone. So they're all like condos and that type of thing. So I think I understand your question, but I think in order to implement it, it would be very difficult to do so.
Deputy Mayor Lavoie.
Yeah, I just wanted to respond to Councillor Bard's question as well by stating that, I mean, we don't have an intent to legalize short-term rentals in residential zones. So not having that concern at this point with regard to a licensing bylaw, those would be the types of techniques that a municipality who had, as Mr. Vadeboncourt indicated, permitted uses included for short-term rentals in their residential zones would use that type of technique to minimize the impact on diluting the residential character of neighborhoods or limiting the amount of disruption. We don't have that situation at this point.
Thank you. Any other comments at this time or questions for Mr. Van Boncourt? Councillor Young?
Thank you, Mayor. I just was going through the report as I did earlier, and there seems to be a bit of conflict, Mr. George Van Boncourt, in that number 2, it says, shall continue to seek compliance through orders under the Municipal Act, Section 440. And yet further on in the report, it indicates it's almost next to impossible to get a conviction there. So what's the point? I mean, you can say that, but what's the point of inserting that when it's almost next to impossible, as I indicated, to get a conviction in the court?
Through you, Your Worship, I don't recall having stated that. If you could refer that section, but certainly that was not the intent. If I miswrote something, the example that was provided to me with respect to a Section 440 was pretty straightforward in terms of preparing the information and bringing it forward to the Superior Court. And obviously, the defendant would have been given the opportunity to make a defense, but if the affidavits and the evidence provided shows that the use was taking place, then it should be fairly straightforward that an order to cease under a Section 440 would be issued by the court.
May I follow up on that?
Supplemental?
Yeah, thank you. Yeah, the issue, Mr. George Van Boncourt, is that throughout this, the issue was witness statements. How do you get the unwillingness of witness statements, i.e. evidence, their statements, and you've indicated it's difficult to get that. So that's when I'm relating it to, you were suggesting proceed to 440. It's a bit of the way I read it, it's a bit of a waste of time.
Thank you, Councillor. That clarifies things for me. I think you're referring to a charge under the Provincial Offences Act, under the zoning bylaw. The witnesses that would be required for that would be the renter. So the person who rented the short-term rental, you'd have to call them back. They would have to be a witness to say that they rented the unit for such and such a date, et cetera, et cetera. A Section 440 is basically the witnesses are the neighbors, the people that have observed that there's been, short-term rental accommodation taking place a property next door to them or, 2 doors down. So it's a different witnesses, one under the zoning bylaw, which is very, very difficult, Provincial Offences Act. Threshold of proof is harder to reach versus a section 440.
Okay. All right.
Yeah, and I'm not going to belabor the point, George, but a witness is a witness is a witness, whether it's for 440 or for provincial court, and it all depends on whether they're prepared and willing to be a witness in court. There's no difference. It's willingness on the part of the neighbors or not. So, it's, but anyways, I'm not going to belabor the point, but that's my observation of that issue.
Deputy Mayor Lavoie.
Yeah, thank you very much. Through you, Mr. Mayor, to Councillor Young. I don't think we want to take any tools off the table is really what we're saying here. So if there's an opportunity that the right evidence provides itself to follow a particular path, then that's the path of that we would follow based on the probability of success.
No, perfect. So, sorry, did you want to respond to that?
No, I don't want to respond to that. I got another question for Mr. Venagvakur.
Okay.
Just number 4, that council directs staff to continue to explore third-party enforcement services, period. I put the period in there. Why Grancia's Host Compliance Service? Why that company as opposed to staff report in terms of other companies doing the same thing?
Through you, Your Worship, they're the leader in the field. Everybody that I've spoken to and through the benchmarking, if they're involved with a third party, they're using Granicus Host Compliance. They have the market, and I'm not aware. I could be wrong. Maybe there's others out there, but they're the ones that are used by a number of municipalities.
No, thank you for that. And I agree, Mr. Van Boncourt, because that was an issue addressed last term of council, but they are the leaders in the industry and who could provide the menu of items that we could pull off to assist in identifying and monitoring them. So, okay, so if there's no other questions, Madam Clerk, could we have the motion read, please?
Moved by Clark, seconded by Lavoie. Be it resolved that DS 2025-004, George Vadaboncourt, Manager Planning Special Projects, Options Report to Address Illegal Short-Term Rental Accommodations in Oro-Medonte, revised, be received and adopted. That Council approve option number 4, implement a licensing program for legal short-term rental accommodation and bed and breakfast uses, as well as continue to seek compliance through orders under the Municipal Act, Section 440, where necessary to prohibit illegal short-term rental accommodations. Number 2, that Council direct staff to prepare a draft licensing bylaw as recommended in the report. Number 3, that Council direct staff to host a public information/consultation session on the draft licensing bylaw, which would include A, information on how it relates to the licensing of legal STRAs, only permitted in 2 zones in the township and bed and breakfast establishments. B, information on the requirements to obtain a license. C, steps the township would like to enforce would take to enforce the licensing bylaw if enacted by council. D, information on the administrative monetary penalty system and how it works. 4, that council directs staff to continue to explore third-party enforcement services provided by Granicus Host Compliance Services, and that staff report back to council on the comments received at the public information consultation session and recommended next steps.
Thank you very much, Madam Clerk. And before I call the vote, I would just like some clarity so the public knows and those watching at home. is how will the public engagement piece be advertised to let people know where and where it will be executed and when they can attend?
Your worship, we'll work with our communications department to ensure that it's broadly notified out to the public of when the session is taking place, the date, make sure that it's on various platforms in accordance with our engagement policy that council has in place.
Perfect. Thank you very much. Councillor Clark.
Thank you, Mr. Mayor. Through you to Mr. Vadamakor. Just to confirm the definition for bed and breakfast, those would be ones that are already licensed under our bed and breakfast bylaw?
Through your worship, that's correct.
Okay, so I'll call the vote. All in favor? Any opposed? Seeing none, that is passed. Okay, thank you very much. And if someone could bring Councillor Shell back in, that'd be fantastic. Once the councillors returned, Mr. Binns, Mr. Vadamakor, if you'd like to provide summary comments to item 11B. But just hold 1 second. Perfect. There we are. Okay. Thank you, Councillor Shell, and welcome back. And CAO Binns, when you have a moment, if you want to continue with a summary.
Thank you, Mayor Greenlaw, through you to members of council, members of the gallery, and the public. The report before council today provides a summary of the evolution of the discussion surrounding Barrie's lands needs, going back to Mayor Nuttall's request in 2023 and the provincial appointment of the land development facilitator in June of 2024. Just by way of background, as the first step of the provincial facilitation process, the parties agreed that an objective and impartial assessment of both employment and residential land needs within a defined study area be conducted. Hemson Consulting was engaged to complete that assessment, and the report and its findings were presented to council on December 11th of 2024. Following that report, council passed a motion supporting continued engagement in the facilitation process and directed staff to report back to council with recommended next steps, a proposed work plan, and associated costs of those next steps in January. This position was taken by Springwater as well as the City of Barrie. However, as we've outlined in the staff report, and you've heard tonight, Barrie in its resolution did indicate that 4,000 acres are needed, as it estimated that 40% of the lands will be undevelopable, given its experience with its annexation of lands in Innisfil. This is in contrast to the almost 2,300 acres of community residential lands identified in the Hemson report. As outlined in the analysis section of the report, Hemson has prepared a preliminary scope of work and a budget estimate of nearly $600,000 to address the various phases. Staff are of the opinion that this is premature, given a number of questions that and clarification I think that needs to come out of stage 2. And I'll draw your attention to page 7 of the staff report, which raises a number of points regarding stage 2 and its considerations. The original proposal to Oro-Medonte from the City of Barrie was for employment lands. The stage 2 findings from the Hemson report concluded that Barrie did not need additional employment lands to meet its projections to 2051. Moreover, its short-term need could not be satisfied with the lands in Oro-Medonte due to servicing, transportation, and environmental constraints. The other point draw attention to is that there's a requirement, I think, to clarify the terms. Community area lands under new definitions do include local employment uses. In the new PPS, the provincial planning statement amends the definition of employment lands to more narrowly scope what would typically be viewed as institutional, so manufacturing, warehousing, and movement of goods. So things like retail and office uses aren't included in that new definition. The other piece that a lot of the Hempson report was based on assumptions around growth and a review of Barrie's official plan. In reviewing Barrie's OP, does not appear reasonable given the density of development occurring in the built-up areas and Barrie's greenfield areas. And furthermore, the City of Barrie pledged in 2023 to facilitate the construction of 2,300 housing units by 2031, which equates to just under 3,000 units in each of the 8 years. In reviewing a recent report from the City of Barrie that was published the end of 2024, just under 3,500 dwelling units were started between January 1st of 2023 and December 31st, 2024, which represents almost a 40% shortfall of just over 2,300 units over that 2-year period. And as Hempson outlined in their report, achieving that target would, quote, far exceed any single year's peak housing start during Barrie's growth surge in the late 1990s and early 2000s, and would be 4 times the recent annual average of 600 units per year between 2006 and 2021. And I think the other point is that even if Barrie was to acquire additional lands for development outside of its boundaries, it would be unrealistic to assume that these lands could be brought to market and developed prior to 2031 to meet that commitment. We have had follow-up discussions with Hempson, and Hempson has confirmed that its calculations for the anticipated community land needed by the City of Barrie, both in the 2 growth scenarios that it presented, are the lands, the net developable lands outside of land for constraint. There's also a regional consideration that we believe should be taken into account. And if you look as part of the agenda tonight, you'll see a very different approach taken by the City of Orillia with its MCR that started with a much bigger view and then looked at a more comprehensive planning review of appropriateness of land use. And the new PPS directs that a coordinated, integrated, and comprehensive approach should be used when dealing with planning matters within municipalities across lower, single, and upper tier municipalities. So based on all of those points, we have outlined 3 options, and I think the recommended option I'll focus on with option 3 is there's a number of key questions that still need to be answered. And as you heard tonight, there is varying positions, and I think to look at how we facilitate a solution, we need to have a common understanding of what the needs are, and that's what staff are recommending in stage 3 is to validate the needs, and that needs to be done before we can look at moving towards a solution. Otherwise, we don't know the problem that we're trying to facilitate. So recognizing that this is a dynamic process, what we're recommending is that we provide the recommended scope back to the provincial land development facilitator. This same process will be undertaken by both Springwater and the City of Barrie. The City of Barrie has tabled a report and is providing feedback. This will be up to the provincial land development facilitator to determine what a recommended scope and path would look like. And what we're proposing is that once that feedback is provided, we'll receive feedback back from the provincial land development facilitator and can report back at that point. But it's premature until a scope of how we determine and validate the needs and some of the assumptions that are built into that report, and then the cost and how that cost may be proportioned out would obviously be determined based on that scope of work. So at a high level, that's essentially what's before you this evening, and I'll maybe just turn it over to Mr. Vadeboncard if there's anything he would like to add.
Thank you, Mr. Binns. I think Mr. Binns has covered it very well. Thank you.
Thank you, gentlemen. I'll open the floor for comments at this time by any members of council. Deputy Mayor Lavoie.
Yeah, I just want to say that thank you to council for your support in going through this process. And I do think it's important to say that whatever we do, we need to stay at the table because we don't want to solicit a response from the province which might be less than we could otherwise negotiate. So I think it's very important. I want to thank the residents for their continued encouragement in dealing with this matter. And for providing their input. So thank you very much.
Thank you. Any other members at this time? Councillor Clark.
Thank you, Mr. Mayor, through you to yourself and possibly the deputy. Was there any discussion at this point in regards to cost sharing of the potential Phase 3 report?
That is what they're working through. My personal point, and I think we've discussed it amongst individual councillors, is until Barrie has incurred the cost of what an MCR would have been, which is the proper or the regular process of a request like this, then all those costs should be bared by the requester. It's kind of hard to justify why we have to be paying tens of thousands, if not hundreds of thousands of dollars to defend our own land. But that's my comment. I hope that kind of answers your question of what our position will likely be moving forward. Any other questions or comments? I guess one thing I think that is important that we understand is what Hempson's report said. And the reason I say that is I read the report and it was quite clear that Barrie has enough land to get it to 2051, which would be the outer edge of need asset management that they would respectfully be required to do. And if they have it, that's 10 years more than what is normal, which is 20 years. So our neighboring municipalities stated something very different in the media in regards to what the report said, and it backed their position in the need. So I think, we need to understand in bullet forms on one page from the facilitator, what does the report actually say? And we need to clearly understand what Barrie's real needs are. And a lot has changed. They doubled their land request 2 hours before the report was put out. It's been clearly stated they don't need employment lands. They've clearly stated days before the report came out that that's what they want that land for, employment lands, and they have far exceeded where they need to be with their housing. The report says the opposite from my interpretation of it. So this is where we need clarity. So until both sides can take that stance that they understand the report identically, we'll never have an intersection to come to an agreement on what's best for the region moving forward. And you know, as much as there are shortcuts from time to time, I think when we're facing two urban centers on each side of our municipality looking for more land, the experience with our northeastern neighbors has been, I feel, much more respectful and fair from how we're trying to get to a same place. At the end of the day, what we are as Oro-Medonte are trying to do is what's best for the area and the region. So, you know, if the facts prove that that land needs to be shifted, that's one thing, but I don't see the evidence at this point, neither has anything that's been reported to council. So we will continue to do our best, but until we actually know what is being negotiated and what that report says, and we have a land on a ground of commonality, we will not come to a resolution, and it'll end up being a provincial decision, which the deputy and myself had a meeting with Calandra about another topic, but at the conclusion, he's quite confident that we can figure this out without having the province engage their will. So, Councillor Young?
Yeah, thank you. Just for a point of clarification, they're good with their land needs until 2051. Does that include what they annexed from Innisfil? Yes?
Correct.
Because I'm going to assume that by that date they'll have water and sewer and all that, or that's the plan, is it?
Yes, and the Mayor of Barrie has approached the government with the finance minister at a budget presentation a week ago that we were both at, and he has requested that the province help the city of Barrie get the wastewater and water pipes down to the employment lands in the south. So, Madam Clerk, if there's no other questions, I will ask for the motion to be read, please.
Moved by Bard, seconded by Young, be it resolved that DS 2025-005, Sean Binns, Chief Administrative Officer, George Vadaboncourt, Manager of Planning Special Projects, options report regarding City of Barrie proposed boundary expansion, Hempson proposed Phase 3 analysis and study be received and adopted. That council inform the Office of the Provincial Land Development Facilitator that it is prepared to continue to participate with the Township of Springwater, the City of Barrie, and the County of Simcoe as per the parameters outlined in Option 3 in DS 2025-005.
Thank you, Madam Clerk. Any questions regarding the motion? Seeing none, I'll call the vote. All in favor? Opposed? And that is carried. Now we will be taking, I believe, a 5 to 10, so 10-minute break max, and then we'll reconvene at 5:45.
Mr. Mayor, we're live.
Thank you very much, Madam Clerk. We're now on item 11C. May we have the motion, please?
Moved by Shell, seconded by Clark. Be it resolved that DS 2025-008, Kamal Burdna, Manager, Development Engineering, Certificate of Assumption, Whispering Creek Subdivision, Registered Plan 51M119, 2479283, Ontario Limited, be received and adopted. That the township issue the Certificate of Assumption for the Whispering Creek subdivision, being the registered plan 51M119, dated July 28, 2017. That staff bring forward the appropriate bylaw for council's consideration.
Thank you very much. Members of council, the floor is now open for any questions or comments. Seeing none, I'll call the vote. All in favor? Opposed? That is carried. May we have a draft motion for 11D, please, Madam Clerk?
Moved by Hutchison, seconded by Bard. Be it resolved that FES 2025-01, Ralph Dominelli, Executive Staff of Officer, Fire Chief, RE 2025, Fire Dispatch and 911 Answering Services Agreements be received and adopted. That the appropriate draft bylaws to execute the renewal of agreements for dispatch and 911 answering services be brought forward for council's ratification. That the City of Aurelia's Fire Chief be notified of council's decision under the Fire Chief's signature.
Council, open the floor now for any questions or comments. Seeing, I guess the only question I had is the increase, is that aligned with what the increases are in other jurisdictions? I don't know if the deputy chief's online, or if you can answer that, Mr. Benz.
I'll maybe see if the deputy chief is available to answer that. Deputy Payment.
Absolutely. Thank you, CEO Binns. To Mr. Mayor. It's just an industry standard. Often that the increases do go along with the collective agreements that you'll find within the dispatch centers. So with respect to the raises that have been pushed along throughout the comm center, that cost is obviously distributed amongst the end users. Obviously, we would be one of the end users there. So that's a pretty standard expectation of what you can see on a year-to-year basis.
Okay. Thank you very much, Deputy Chief. Okay, so if there's no other questions, I'll call the vote. All in favor? Opposed? There are none. And we'll now move on. That's passed, Madam Clerk. We'll move on to item 12A, reports of municipal officers for information only. We are now at the reports for information, and there is one report to be received. May we have the motion, please?
Moved by Young, seconded by Shell. Be it resolved that the report, as listed under number 12, reports of municipal officers for information only, be received.
Are there any questions or comments with respect to any of the items? Seeing none, I'll call the vote. All in favor? That is carried. Reports and announcements of members of council under item 13A. Are there any updates from members of council of the township representatives with our partners and agencies? Councillor Hutchison.
Sorry, you said partners and agencies. Does this also include updates from committees?
Yep.
Yeah, okay. Well then, thank you. I'll go ahead. With regard to the Heritage Committee, we did meet for the first time really since, I believe, October. This past Monday, we had a short but effective meeting. And just a few highlights with regard to that. The process of designating the Carly Community Hall as a heritage designated building continues. There was a 30-day waiting period that has to lapse between township approval council's approval of that and to continue on with the designation. So that process is moving forward quickly, and the response from the board of the hall has been very positive as well. And folks are probably aware that the Heritage Committee has book sales of a number of different historical books on or the history of Oro and Medonte and Oro-Medonte. And I'm really thrilled to announce that book sales this year actually totaled $2,084.68. Which is amazing, and that money goes back to different activities that the Heritage Committee is taking, working on. So, for instance, the payment of cemetery signs and signage for cemeteries and other areas. So I did want to say thank you to the hall boards for facilitating sales at the halls, particularly around the Christmas season. The Red Shed Supply Company does them on consignment, the books on consignment. And there was a social media Christmas gift campaign this year that was focused on the book sales, and it was actually quite successful. A lot of people did approach the township to purchase books, to the point that the story of Oro was sold out. So, I mean, do we have to look at a reprint? I have no idea, but I think that is very cool, and so kudos to the board members on that. And then the last piece is that I think you'll remember about this time last year, there was a play called The Lost Heroes of Oro. It was presented in Georgian College, and I attended it. It's really a terrific musical, and it celebrates the Oro African Church. And the Lost Heroes of Oro is actually being presented at the Elgin Theatre in Toronto between February the 6th and the 8th. So if anybody's planning on going to Toronto for a trip, they could take in the play, which I think is really cool. So that's it. And then I do have a community announcement as well. Family Day, again, they will be having the cardboard sled races at Sweetwater Park in the Sugarbush community from 11 till 3. The registration for the sled race is $10, but this year the organizers will take donations in lieu of the $10 if people for the food bank. So if people bring in, the equivalent of $10 worth of goods, food goods, you can get your sled in. So and you can register on the day of, or you can register on the Friends of Sugarbush Facebook page. So it's always a really terrific event. I know all of council and the mayor have been invited to attend, and I look forward to it. So thank you.
No, thank you very much, Councilor Hutchinson. And it is a great day they put on. It is, a lot of organizers pitch in, and it's great to see how a lot of the younger kids come in and be a part of that team to keep that event going. Councillor Young.
Just a question to Councillor Hutchison. Is there an age limit for the race?
It's mostly children participate, but I have no problem thinking perhaps a council member of a certain age could make their own cardboard sled and participate.
Okay. Okay, is there any other announcements from members of council at this time, or seeing none? Okay, so we'll move to 13B. Addendum item, where the deputy mayor would like to provide comments.
Just give me 1 second. I have to get back to that page. Yes, it seemed like an opportunity had arisen with the retirement of the CAO for the Nottawasaga Valley Conservation Authority to contemplate whether or not the municipal participants in both of the conservation authorities that have jurisdiction in Oro-Medonte be amalgamated under the Conservation Authorities Act of Ontario. So the purpose of this motion is just to set that process put the wheels under that process and get it started so that each of the municipalities can decide to their own benefit whether it's something worth doing. There are quite a number of municipalities that would be participating in this. Certainly, I think the advantages that can be seen are those of efficiency and consistency and a single reporting process and only one bill to pay and that sort of thing. So I'll leave it. I'll put it on the floor for now, and then we can perhaps discuss it. Thank you.
Okay. So members of council, is anyone would like to make comments or ask questions? Councillor Bard.
Thank you, Mr. Mayor, through you to the deputy. I understand that conservation authorities have the planning aspect, but I also I'm grateful that they look after our local environments and our watersheds. So I guess I would need some kind of reassurance that we're not going to lose that environmental oversight. This would be, we already have a very large region, and to encompass all around Lake Simcoe is, we're going to be getting away from that local protection element that I'm concerned, and that local knowledge. So I think I would need maybe a little bit more time and reassurance that the environment's not going to be compromised. I feel like we need more environmental oversight rather than less at this time, especially looking at some of the events on the news. I just want to make sure that we were protected. We're looking at, what, 500,000 people probably at the southern end of Lake Simcoe compared to our areas. So I certainly wouldn't want to be second tier or an afterthought.
No, I appreciate the comments. Is there any other comments? Councillor Schell.
Yes, thank you, Mayor Greenlaw. Through you to the deputy. Are you suggesting in this proposal that you amalgamate Nottawasaga out and give it to Lake Simcoe or vice versa, or you're thinking about amalgamating and creating a new one?
Yes, through you to Councillor Schell, that's it's precisely the second case. So in essence, what would happen, as I understand it, and there's a process to go through here, and it will be lengthy, and it will involve public input, and it will involve the consent of all the municipalities in order to get engaged into it. But you know, this is going to be something that would largely merge, that would amalgamate the two together under whatever name they might choose to adopt. So the name might well change because there have been as many as 3 that have been previously amalgamated in history. And I think, you know, to perhaps address Councillor Bard's point to some extent, I mean, the employees who provide the services on the ground, the boots, the technicians, you know, all of the people that go out, the planners that take in the information, they're all just be working under the same governance structure now. So it's not like we're just going to cut one off and expand the other one's region. They're going to need all of that labor, all those employees in order to continue to provide the same expertise as they do now. I just think there'd be one source to go to, there'd be one bill to pay, and there would be perhaps a better organized performance standards or key performance indicators to show us, you know, how we're getting from application to permit and those types of things. So that's how I see it evolving in terms of the discussion as we move forward. And as I say, it'll involve quite a bit of work here out.
Thank you for that answer.
No, and I think the due diligence to ensure that the environment is protected and maintained is key. And I foresee the consistency and the efficiencies won't necessarily affect the number of boots on the ground doing the actual work. Like, because you're right, it would technically include a very large area. But I know there are times when even some developers, and I was saying, like, but they have to go through the process too, and there's potentially multiple CAs they have to deal with. So I think we're just trying to see, is there a way of us making it better, right, and more efficient and cost effective. So I see Councillor Clark and then Councillor Hutchinson.
Thank you, Mr. Mayor, through you to the floor. And I think, the goal of something like this, from my perspective, is that consistency. What we don't want to have happen is, when developers or builders or contractors, have trouble getting through the process because it's different from what they do in other jurisdictions, maybe they take a chance to not go through the process. And that's ultimately what I'd like to avoid. I want the standards to be consistent, clear, the process to be consistent and clear so that everyone understands what the rules are, so that when they go to submit for an application, they know what to expect. And they're not just going to say, I'm tired of this, it's different from this one, it's different from this one, I don't want to learn the system again, I'm just going to skip it. And that's, I think, where a lot of potential environmental damage especially can happen, is if the entire process becomes so cumbersome, well-intentioned people just start to avoid it.
Oh, thank you for that comment. Councillor Hutchison.
Thank you, Mayor Greenlaw. Yeah, I can share Councillor Bard's concern about the potential loss of oversight. I too am very environmentally conscious and a heavy supporter of this type of oversight. So for me, if this can begin a discussion with regard to ultimately looking at being able to create efficiencies and speeding up the process, and we've spoken at the table before around concern of the duplication of processes between the CAs and the EAs. So, maybe being able to smooth that out so that when we're being asked for funding, we've got a better sense of what we're paying for, because that has come up as a discussion. And potentially, by doing so, we could look, and again, it's a big potential, but perhaps like between the two associations, we pay $377,000 a year for their services. So, if we're able to look at an amalgamation process that builds in some efficiencies, perhaps we could also get the price down a bit.
Okay, no, thank you. Any other comments or questions? Councillor Young.
Yeah, thank you, Mayor. The Severn Sound Environmental Association, I guess at this point, cannot join or be amalgamated. I understand this is something you put on the floor for discussion, and in terms of amalgamating these two bodies together, but I'm just curious as to whether that could be brought in at some point, the Severn Sound Environmental Association. But I understand it's not a conservation. It's not a conservation authority under the Act.
No, you're correct. At this point, I think it's not to say it's not something that could be considered at a later time or down the road, because it isn't a CA, and that's where fortunately or unfortunately, it makes them vulnerable, because it's not mandated that you have to pay into it. And I think it needs to hopefully harbor somewhere where it can be in a better situation to ensure its sustainability, because it does bring value in source water protection and the duties that they do fulfill. Okay. Councillor Bard.
Thank you, Mr. Mayor, through you. I guess if this process was to go further, and you said it was going to take a fairly long time, and NVCA is currently looking for a new CAO or has a vacancy there, I think it would be prudent to share with them that maybe some of our concerns of inefficiencies are what we're looking for, and that could be part of their recruitment process to target a candidate that may improve some of those, and then maybe this process wouldn't need to go further if that was to be something that happened.
No, fair comment, but I think what the deputy mayor is bringing forward, saying, look, here's something that should be addressed at this time, and the timing is right, and all we're doing is engaging. I believe if it passes, is we're engaging discussion to identify the things. It's a long way from all the municipalities would have to weigh in, and the board members would have to get together in order to agree for this to transpire. So I think what it is we're just starting the discussion and looking for more efficiencies and more consistency within our conservation authorities now and moving forward. So it will take some time, but I think, I think it's a good thing to at least initiate discussion, and let's see if there is potentially a better way forward. Any other comments at this time? Then, Madam Clerk, is there a motion? Or so first of all, is there a motion, and is there a seconder on the motion? Councillor Clark?
Mr. Mayor, I'll second the motion.
Okay.
Moved by Lavoie, seconded by Clark. Whereas conservation authorities are legislatively empowered by Conservation Authorities Act of Ontario to provide for the organization and delivery of programs and services that further the conservation, restoration, development, and management of natural resources in watersheds in Ontario. And whereas there are both the Simcoe Regional Conservation Authority, the LSRCA, and the Nottawasaga Valley Conservation Authority, the NVCA, together to be known as the authorities, with jurisdiction in the Township of Oro-Medonte. And whereas the Township of Oro-Medonte believes there is an advantage, or to be advantages of economics, consistency, timelines, and governance to amalgamate the authorities. And whereas the Conservation Authorities Act of Ontario, Part 3, Section 11, provides for a participating municipality to call a meeting to consider the establishment of one authority to have jurisdiction over the areas that are under separate jurisdictions, the meeting. Now and therefore be it resolved that the Council of the Township of Oro-Medonte hereby directs staff to call the meeting to consider amalgamating the authorities, and to give notice to of the meeting to each participating municipality to consider the establishment of one authority by way of amalgamating the authorities. And to do such other things as are necessary to fulfill the requirements of the Conservation Authorities Act of Ontario, Part 3, Section 11, that will cause the necessary parties to consider the amalgamation of the authorities.
Okay, thank you very much. Any questions regarding the motions before we call the vote? Councillor Young?
Sorry, just one question. Have the other municipalities been advised of this, or is this just first step sort of thing, putting this?
This is a first step.
Okay,
right?
so they haven't been advised, but no feedback is yet.
There has been talks amongst different municipalities, and there may be other motions coming forward. That's up to the other municipalities as well, but it just engages the discussion as part of the process. Okay, so everyone's heard the motion. I'll call the vote. All in favor? Opposed? And that is carried. Okay, so we're now to item 14, consent agenda. Is there any items on the consent agenda that any member of council would like to pull for further discussion? Seeing none. Madam Clerk, we have a motion to receive the consent agenda, please.
Moved by Lavoie, seconded by Shelby. It resolved that the staff recommendations with respect to the items listed under consent agenda correspondence be adopted as printed.
All in favor? That is carried. Item 15, communication petitions. We have none this week. We have no notice of motions this week. So item 17, bylaws, may we have a motion for the draft bylaws under item 17, please?
Moved by Hutchison, seconded by Clark. Be it resolved that bylaws number 2025-002, 2025-003, 2025-004, 2025-006, 2025-007 be read a first, second, and third time, passed, be engrossed by the clerk, signed and sealed by the mayor.
Members of council, is there any comments or questions regarding any of the draft bylaws before us? Seeing none, I'll call the vote. All in favor? Opposed? That is carried. We've done closed session, so we don't have to deal with it
No,
now.
we have other,
wait,
we
we're
have to
going
go
back
back
in?
into closed session.
Okay, so may I have a motion to go into closed, please?
Moved by Bard, seconded by Young. Be it resolved that we do now go back into closed session at 6:17 p.m. to discuss litigation affecting the municipality, insurance claims, labor relations, employee negotiations, CAO performance.
Okay. Call the vote. All in favor? That is carried, and we'll see everyone back in closed. Thank you very much.
Mr. Mayor, we're live.
Thank you, Madam Clerk. We have a motion to rise and report out from close, please.
Moved by Hutchison, seconded by Shell. Be it resolved that we do now rise at 7:04 p.m., at which time we shall report on the closed session items 18A, B, and C.
All in favor? Opposed? That is carried. May we have a motion for item 18A, please?
Moved by Bard, seconded by Lavoie. Be it resolved that the confidential information, verbal information, presented by Sean Bin, CAO, Shannon Johnson, Director of Finance, Chief Financial Officer, re-litigation affecting the municipality, insurance claims be received, and that staff proceed as directed by council.
Thank you. All in favor? That is carried. May we have a motion for item 18B, please?
18D.
D.
18D, yes. Moved by Clark, seconded by Hutchison. Be it resolved that the confidential verbal information presented by the Human Resources Committee, Labor Relations, Employee Negotiations, CAO performance be received.
All in favor? That is carried. And I apologize, I haven't marked as C on my agenda.
Yes, Mr. Mayor, those are the closed session minutes that were approved, and you are correct. I did say we were going to report out on A, B, and C, but we are actually reporting out on A and C for clarification.
Okay.
Thank you.
So does that now bring us to the confirmation bylaws?
And just give me a moment. Moved by Shell, seconded by Bard. Be it resolved that bylaw number 2025-010, being a bylaw to confirm the proceedings of the council meeting held on Wednesday, January 22nd, 2025, be read a first, second, and third time passed, being grossed by the clerk, signed and sealed by the mayor.
Thank you. All in favor? That is carried. And may we have a motion to adjourn, please?
Moved by Young, seconded by Hutchison. Be it resolved that we do now adjourn at 7:06.
All in favor? That is carried. Thank you very much, and hopefully everyone stay bundled up until it gets warmer.